8 years. 8 years families have waited, watched, and wondered if the federal government would ever answer a question that shouldn't have taken this long. How do you get your Second Amendment rights back? Federal gun rights restoration is no longer a theory, no longer a rumor passed around in gun shop parking lots. As of August 17, 2026, it's real, it's written into law, and it's about to change lives for hundreds of thousands of Americans who have been living as second-class citizens under their own constitution. The Department of Justice just dropped a 4-page final rule on the federal 925C restoration process. And if you think the government moves fast on anything that benefits regular people, think again. This rule sat dormant, unfunded, ignored. Since 1992, 3 decades. 3 decades where a person could serve their time, pay every fine, rebuild their entire life, and still be told by their own government, no, you don't get your rights back. Not now, not ever. That ends, at least on paper, this year. And I am not going to sit here and pretend this is some dry bureaucratic footnote. This is about people. This is about your neighbor who made one mistake 20 years ago and has been paying for it every single day since. This is about veterans, about people convicted of decades-old nonviolent offenses, about Americans who the Constitution was supposed to protect, and instead, the system buried. Before we go one inch further, if you care about accountability, if you care about the government actually being forced to explain itself instead of hiding behind legal jargon nobody reads, hit that subscribe button right now. Drop a comment telling me where you're watching from and whether you or someone you know has been affected by federal gun prohibitions. Share this with somebody who needs to hear it, because I guarantee you, somewhere in your circle, there's a person who has no idea. This door just opened. Let's get into what this actually is, because too many people are confused about the difference between state and federal restoration, and that confusion has kept people from even trying. Under federal law, 18 U.S.C. JDR, there's a whole list of categories that strip you of your right to own a firearm. Felony convictions, certain misdemeanor domestic violence convictions, dishonorable discharges from the military, mental health commitments, fugitive status, the list goes on. Now here's the twist most people don't understand. You can be prohibited at the state level and the federal level simultaneously, and fixing one doesn't automatically fix the other. In a lot of states, if you get a pardon, an expungement, or your record set aside, and the federal government recognizes that state process, your federal rights come back with it. Sounds simple, right? Except it's not, because plenty of states either don't have that process at all, or the process is so broken, so expensive, so buried in red tape that it might as well not exist. Think about that for a second. You could be a completely rehabilitated person decades removed from a mistake and still be told by your state, sorry, there's no path forward for you here. That's not justice. That's a government that gave up on rehabilitation and decided permanent punishment was easier than actually doing its job. So who benefits the most from this newly reopened federal process? 3 groups. And I want you to really sit with these, because these are real Americans, not statistics. First, felons, specifically 2 kinds. People convicted of a federal felony where a state has 0 jurisdiction to restore their rights, and people with state felonies in states that simply don't have a workable restoration system. Pennsylvania is a textbook example, technically not impossible to restore rights there, but practically speaking, good luck. This federal process gives those people an actual avenue, something they've been denied for years. Second group, people convicted of a misdemeanor crime of domestic violence. I want to be clear about something here, because this is where people's emotions run hot, and rightfully so. Domestic violence is serious, and I am not here defending abusers. But under federal law, a misdemeanor domestic violence conviction creates a permanent, lifetime firearms prohibition. A misdemeanor, treated with the same permanence as violent felonies, and most states have absolutely no mechanism to undo that. No matter how much time has passed, no matter how much a person has changed, that's not proportionality. That's a blunt instrument being used where a scalpel should be. And third, dishonorable discharges from the military. Think about the layers of failure here. A person serves his country, gets discharged dishonorably, and then is told for the rest of their life that they cannot exercise a constitutional right, that this exact government sent them overseas to defend for other people. Let that sink in. Now, not everybody wins big here. If you're a fugitive from justice, this rule presumes it will not help you, and frankly, the message from DOJ is blunt. Turn yourself in first, deal with your outstanding warrant, and then we'll talk. And people with mental health commitments. This is a category where the final rule actually got tougher, not easier. And we're going to dig into exactly why that matters and who it's going to hurt. Here's something the mainstream coverage of this story completely buried. And it's the most important sentence in the entire 144 pages, if you ask me. The Department of Justice is reopening this process, at least in part because they recognize that permanently stripping a constitutional right over a decades-old conviction is very likely unconstitutional. Read that again. The government is quietly admitting that the way it's been treating millions of Americans for over 30 years probably violates the Constitution it swore to uphold. And instead of a headline, instead of outrage, instead of accountability, we get a bureaucratic rule change buried in legal language most people will never read. That's the game. That's how the system avoids consequences. It doesn't apologize. It doesn't hold anyone accountable for 3 decades of stonewalling. It just quietly opens a door and hopes nobody asks why it was locked for so long in the first place. Let's talk about what it actually takes to apply, because this is not a form you fill out on your lunch break. You need fingerprints. You need a full written statement explaining every single reason you're prohibited, not a summary. Every reason. You need court documentation from the indictment, from the information, from the plea deal, from any finding of guilt, and any statement of facts read into the record. You need documents from probation or parole. You need proof of when you were released from incarceration. You need to write your own affidavit. And you need 3 separate people to write affidavits vouching for you. This is not a light lift. This is the kind of paperwork trail that can take months to assemble. And if you're missing pieces, your entire application can stall or get denied. If this is hitting close to home for you, if you're sitting there thinking, this is exactly what I've been trying to figure out for years, do me a favor and hit that like button and comment below with your biggest question about this process, because I read every single one and I want to know what's actually confusing people so we can dig deeper in future coverage. This isn't content to me. This is real people's lives. Now let's get into what actually changed between the proposed rule from the summer of 2025 and this final rule that just dropped, because the differences matter, and some of them are genuinely significant wins for applicants, while others show you exactly where the government still isn't budging. First, certified records. Under the original proposal, every single court record had to be a certified copy, expensive, slow, and in some jurisdictions, nearly impossible to obtain quickly. The final rule loosens that. If certified records are genuinely difficult to get, a true copy stamped by the court clerk can now substitute. That's a real, tangible relief for people navigating overloaded court systems, especially in rural counties where clerks are underfunded and understaffed. Second, and this one matters more than people realize, if records simply cannot be located, and it's not because the applicant failed to try. The final rule allows you to submit a written declaration explaining your efforts and why the records don't exist, courthouse fires, floods, records destroyed after a retention period expired. These things happen more than you'd think, and under the old proposal, that could have been a dead end. Now, it's not automatically disqualifying. Third, the application fee. Originally proposed at $20, it's now $30, with DOJ reserving the right to review and adjust that periodically, which, let's be honest, almost certainly means it goes up, not down, over time. Keep that in mind if you're thinking about applying. The window where this costs the least amount of money is right now. Fourth, and this is a big one, the affidavit requirement around controlled substances. Applicants have to swear they're not an unlawful user of or addicted to a controlled substance. Historically, that swept marijuana users into permanent firearm prohibition, even in states where marijuana is completely legal. But earlier this year, the Supreme Court's ruling in the case now known as Hamani found it unconstitutional as applied to strip firearm rights from a regular marijuana user. Because of that ruling, DOJ's final rule now excludes marijuana from that controlled substance declaration for purposes of this application. That is a meaningful, real shift, and it raises an obvious question that DOJ has conveniently avoided addressing directly What happens to Form 4473, the form every single person fills out at a gun store, which still asks that same question and still, as of today, includes marijuana? If the federal government just admitted in a formal rule that marijuana shouldn't count against you here, how do they justify still counting it against you at the point of purchase? That's a contradiction sitting right out in the open, and somebody in Washington needs to answer for it, not just quietly hope nobody notices. Fifth, Chief Law Enforcement Officer notification. Under the proposed rule, the burden was on the applicant to notify their local CLEA that they were applying. Now, DOJ handles that notification directly after you submit. The local law enforcement officer still gets notified and still gets a chance to weigh in, but the responsibility has shifted off the applicant's shoulders and on to the department's. Small change, meaningful reduction in the burden on ordinary people navigating an already complicated process. Sixth, foreign criminal records are now required if they would have counted as a prohibiting offense. If you've got a conviction overseas that wouldn't independently prohibit you under federal law, but you're also applying to restore rights connected to a domestic conviction, DOJ wants that foreign record disclosed and translated into English. They want the full picture, not a partial one. Seventh, military records. And this one applies broadly, not just to dishonorable discharge cases. If you ever served, your military records are now required, regardless of whether your prohibition has anything to do with your service. DOJ is being upfront about why they want a complete risk profile on every applicant, not a partial file with convenient gaps. If you've made it this far, that tells me you actually care about how this country treats people who've already paid their debt, and that matters more than any algorithm. So subscribe if you haven't. Drop a comment with which of these changes surprised you the most. And let's keep pushing this conversation forward instead of letting it disappear into a government press release nobody reads. Now let's talk about the group that got hit hardest in this final rule compared to the original proposal, people with mental health commitments. Under the final rule, a mental health-based application will only be considered if you can demonstrate you've already exhausted every possible state-level restoration avenue and failed. That means if you live in a state with zero restoration process for mental health prohibitions, you may have a path forward federally, but if your state does have a process, you are required to go through it. Fail at it before the federal government will even consider your case. And even then, DOJ has been blunt. It's unlikely, though not impossible, that they'll overturn a state's decision. Think about the message that sends to people managing their mental health responsibly years or decades removed from a commitment that may have happened during a genuinely difficult period of their life. The bar isn't just high, it's stacked against you by design, and that deserves scrutiny, not silence. Now let's talk about the categories. DOJ presumes permanently ineligible because this is where the rule draws some hard lines and rightfully controversial ones. If your underlying conduct resulted in someone's death, if it involved rape, arson, and a list of similarly violent offenses, you are presumed permanently ineligible for restoration. That presumption is technically rebuttable, meaning you could theoretically build an extraordinary case proving you're different from others in your category, but DOJ is signaling clearly that they expect very few people in these categories to succeed. And look, for violent offenses like these, most reasonable people are going to understand why the government is being cautious here. This isn't the fight worth having. But here's where it gets interesting. DOJ actually walked back permanent ineligibility for 3 specific categories, replacing it with a 10-year rebuttable presumption instead. Nonviolent felony gun offenses. Think firearm possession on school property that wasn't tied to any violent act, just inadvertence or a lapse in judgment that turned into a felony charge. After 10 years with a clean record, you're now presumed eligible instead of permanently barred. Same for nonviolent explosive-related felony offenses, and the same for felony-level animal abuse convictions. After a decade of staying clean, DOJ is now willing to presume these individuals have demonstrated enough rehabilitation to move forward. That's a meaningful softening from the original proposal. And it shows this rule isn't static. It's a government slowly, reluctantly adjusting its posture toward permanent punishment. Let's talk numbers, because this is where you really see how uncertain even the government is about what they've unleashed here. In the original estimates, DOJ expected roughly 1 million applicants in the first year. In the final rule, they slashed that projection down to 330,000, and based on the last 3 years of firearm purchase denials at the point of sale. Here's my problem with that number, and I want you to think about this critically, with me. That figure only counts people who actually tried to buy a gun and got denied. It says nothing about the countless Americans who know they're prohibited and never even attempt to purchase because they already know the answer. The real number of people eligible for this process is almost certainly far higher than 330,000, and DOJ's own estimate might be dramatically underselling the scale of what they're about to face. That's not a minor miscalculation. That's the kind of number that determines staffing, processing time, and whether the system actually functions or collapses under its own weight the moment it opens. And here's the part that should make every single person considering this application slow down and get it right the first time. If you apply and you're denied, DOJ will presume you ineligible for the next 5 years. 5 years? You can technically reapply immediately, but functionally it won't matter because that presumption of ineligibility follows you. This is not a process where you get to take a swing, see what sticks, and try again next month. One shot, largely, for half a decade. And that should tell you everything about how seriously this needs to be approached, how thoroughly the paperwork needs to be assembled, and how carefully every single detail needs to be verified before submission. Do you need a lawyer to do this? No, let's be completely honest with each other. You can absolutely put this application together yourself if you're organized, patient, and willing to chase down every single document. But given that a mistake costs you 5 years, given that the fee is still relatively low right now compared to where it's likely headed, a lot of people are going to reasonably decide this is worth getting professional guidance on. And that's a personal call only you can make based on your own situation and your own risk tolerance. Here's the timeline, and this is the information that actually matters if you're planning to move on this. 30 days after the rule's publication, DOJ begins accepting applications from those they invite to apply. 75 days out, they'll accept their first batch, 5,000 applicants, almost certainly through the new web portal DOJ has been building, even though the rule itself doesn't explicitly mandate electronic-only submission. That puts us somewhere around early to mid-November of this year, and for that first wave. After that, at the 120-day mark, they start accepting additional batches of 500 applicants at a time on a rolling basis. None of this rollout schedule is written into the actual rule. It's posted separately on the DOJ website, which means it is absolutely 100% subject to change without warning. And I want you to internalize that. The government has shown us over and over that timelines are suggestions until they're not. My advice, and I say this as someone who has watched government processes get bottlenecked, delayed, and mismanaged more times than I can count. Start now. Get your fingerprints done. Start requesting your court records today, this week, not the week the portal opens. Draft your affidavit and line up the 3 people who are going to vouch for you, because when that portal goes live and that first batch of 5,000 slots opens up, the people who are ready are going to be the people who actually get through. And everyone scrambling to gather documents after the fact is going to be sitting in a queue, watching other people move ahead of them. This is a story about a government finally, grudgingly admitting it got something wrong for over 30 years. It's a story about real people, felons who paid their debt, veterans carrying a dishonorable discharge, people convicted of misdemeanors decades ago finally being handed a door that was bolted shut since 1992. But it's also a story about a government that still hasn't fully reckoned with how it treats people with mental health. Histories that still can't give you a straight number on how many people are actually affected, and that reserves the right to change fees and timelines whenever it feels like it. Accountability doesn't stop the moment a rule gets published. It starts there. We are going to be watching this rollout, tracking every delay, every denial pattern, every broken promise, because that's what real journalism is supposed to do. Not celebrate a press release and move on, but actually follow through and make sure the people this rule claims to help actually get helped. If you found this valuable, if you think more people need to understand exactly what's changing and exactly what's at stake, subscribe right now, hit that like button, and leave a comment telling me what you want covered next as this rollout unfolds. Because I promise you, this is not the last time we're going to have to talk about whether the government is actually keeping its word. Share this with somebody who needs it. Until next time, stay sharp, stay informed, and never let anybody tell you that asking hard questions makes you the problem.